All right, closing arguments is the last segment. After closing arguments, it's just a waiting game. CPOST administrators will publish the findings when the panel signs off.
We'll take 2 minutes, please.
2?
Yes.
All right. Please proceed.
Thank you. Thank you for your time and attention today. I know it's been a long day and a long couple days before this. The theory of the case today is that there is a pattern of bias-based policing by Officer Williams. He wants to indicate that there is no one stop that can be pointed out, that he has reasonable articulable suspicion on every stop. But I submit to you that the evidence today is going to show you that, or showed you that, based on all the totality of the circumstances, there is a pattern of policing. Bias-based policing is difficult to prove because in Kansas, as I said earlier, we don't just have people blatantly articulating, I stopped you because you're a protected class. That doesn't happen here. And instead, we have to look at all the evidence put together. And I do have just a short PowerPoint that I'm going to kind of show you. In this case, you have to look at all the bricks put together. It's very difficult to just take one stop and say there was bias-based policing on that stop, unless you have some sort of epithet that's used at the time. And so in this particular case, we start with Lieutenant Hagenbush. And in 2016, he addressed with Officer Williams, hey, we've got a concern that you're arresting a much higher rate of females than males. And at the time that Mr. Williams got DRE certified and had his letter of recommendation, that's prior to any of this happening. Everything that's going to come up here is going to be after this first time that Lieutenant Hagenbush addresses this with him, and that people in Douglas County Sheriff's Office are saying, something's not right. But, you know, they ran the numbers, and, well, they were definitely higher than the rest of the agency, much higher, but, well, it's 55% female or so we can't really say that there's anything wrong. So we're going to move on down the road, but we addressed it with you. Next, we have the first stop on Watts. And again, I'm not saying that on Watts. I mean, Mr. Jarr was very thorough and bringing out that, you know, with the stops, there was bad driving. I mean, I'm not contesting that she didn't have her full headlights on. She admitted that. What I am saying is that Mr. Williams had a pattern of sitting outside the 3 strip clubs or exotic dance clubs in Lawrence, and not just sitting outside the clubs. Captain Bellinger testified that, you know, at closing, they would, for safety, sit outside the clubs, and that makes sense. But that's not when he's making these stops. He's making these stops at 3 o'clock, 4 o'clock, 2 o'clock, well, 3, 4, and 5 in the morning, and that's in the reports. So that's not when the patrons are leaving. That's when the dancers are leaving. That's when the employees are leaving. He's sitting outside the bar, the clubs, watching the gals get off of work, and then stopping them. And so the first stop, we have him, you know, Ms. Watts is leaving from the Flamingo. And it's not just that he stopped her. Again, I'm not saying that he didn't have a reason to stop her, but I think what's interesting here is that, you know, she was just shocked. If you look at her report and the testimony, saying that he's indicating that she had an odor of alcohol. I mean, she said at one point, the testimony was, she said to him, "Are you serious?" She's on ADHD medication, so her kind of confusion and not being able to pay attention to the stimulus, it makes some sense for that. But it's not just the fact that she says, you wouldn't smell alcohol on me, because, again, we have an experienced panel that, as Mr. Duro pointed out earlier, you know, often people don't say how much they've had to drink, or they don't think the stop is accurate, or you can't smell marijuana, whatever it is. But in this case, we've also got the sergeant on scene that changed her handcuffs saying, I didn't smell alcohol. And then we have, according to Ms. Watts, once she went to the jail, the person that patted her down at jail says, I don't smell alcohol on you, and you should call and make a complaint. When you add that all up together, I believe that there's an issue with that stop that goes to over-policing, that goes to the integrity, and that goes to, you know, that just starts to build a pattern of not only bias-based policing, but is there a good moral character issue with the stops that Mr. Williams is making and what he's documenting. She also indicated that she was very terrified that he would pull her over again, and that in fact that he did. Then you have the second Watts stop, which is just a week or two later. And at that time, Ms. Watts indicates that she believes she's stereotyped for where she works. I think that goes to, I mean, these are female dance strip clubs, so the people that work there are females. That is where he's going to sit off. And Mr. Williams wants you to believe that, oh, he just stops whatever driver he sees in front of him, but he's intentionally positioning himself at a time and a place where it's going to be the females that are leaving. And so she indicates that she believes she's targeted. She also believed that he recognized her car, and she told the captain that it was a very distinctive car. Mr. Williams actually admitted when he was questioned about it that he recognized the car. He said it was after he initiated the stop. And so, and then the report, and this is Exhibit 2, also states on page 10 that Williams contacted Watts and the two immediately recognized each other. And so again, it's up to the panel to decide what can he see and what can he not see. On August 12th of 2016, it was not a stop at this time, but it was, again, Ms. Watts is leaving work, and according to her, he pulled out after her. According to Mr. Williams, she pulled up behind him. I don't know which is the case, but either way, again, she felt scared, and she indicated that, and she felt like she needed to get documentation, probably, you know, putting herself kind of at risk by stopping and taking a picture of him to document what he was doing. And at that time, Mr. Williams indicates, well, yeah, I saw who she was, and when asked about it by his, at that time, Supervisor Sergeant Armbruster, he indicated that, you know, he wasn't, I believe the words were, I wasn't going to fuck with that. But, so at that point, he's seeing who she is, did not make the stop at that time. So then we add the Volkman traffic stop, and again, not saying, she was very belligerent during the stop, but I think it's interesting to note here that Mr. Williams watched her walk out of the strip club. According to him, she stumbled. He didn't document that. And so again, that's a question of good moral character, why he's not documenting what he's observing. But on the body cam, he can be heard, or on the video, he can be heard saying she and her, as far as when he's, I think he's running speed at that time. But again, when he has contact with Volkman, you know, she's basically saying that she believes she's being targeted, and that, and indicates that she had concerns about Mr. Williams. Then in 2017, there was, Captain Bellinger testified that a defense attorney contacted him regarding Shy Jackson, and the defense attorney told him that Ms. Jackson was stopped 4 times in a couple of months, that there was a DUI arrest the first time, but the charges were dismissed because of no impairment for the KBI lab. And also, circling back to Ms. Watts' first stop, her DUI was also dismissed. But Ms. Jackson, her first case was dismissed. The attorney expressed concerns that there were 2 stops that Mr. Williams didn't call dispatch on, and so there wasn't a record of those stops. And then he specifically stated that after watching the video, the body cam, the attorney believed that Mr. Williams was exaggerating the truth about Jackson's driving. And so again, we're starting to have that pattern. We're starting to have that good moral character of, are there exaggerations about what he's actually observing and what he's seeing. We have Captain Bellinger's name on the Paradise bathroom wall. I know that the panel at first felt that wasn't relevant, but I believe it's absolutely relevant that in one of these dance clubs that employees, besides probably some security, maybe bartenders, but employees, females, they think that someone thinks it's necessary to write in the bathroom, if you have a concern about Bradley Williams, call his superior. And could it have been, we don't know who wrote that, could it have been someone that was upset because Mr. Williams pulled him over? Sure, but it actually worked in the fact that then that's where Ms. Volkman got his number, and then that's where Ms. Jackson got his number. So we've now got a pattern of people that he's stopping, and females in the female bathroom that are concerned about this particular officer and how he's treating them and how he's targeting them. Next we have, in 2019, Captain Cooper, some concerns were addressed to him, and that was, if you look at Exhibit 7, page 11, that was because an attorney mentioned something, and so he looks at the numbers in 2019, and that's now when Mr. Williams is over at Lawrence Police Department. So again, we've got an attorney saying something's going on here, but they run the numbers and they were like, well, you know, maybe slightly higher female, but we don't really see anything there. But we've got this persistent, pervasive pattern starting in 2016 where people are saying something is not right with his policing. Then you have the complaint by Douglas County, by now Sheriff Armbruster, to the Lawrence Police Department, and that was in August of 20, saying we have concerns about what he's doing. And that initiated the Lawrence Police Department complaint. So I think one thing I will say is, as I said, this is a pattern here, and we sort of have these bricks that make it up. Not all these bricks should be the same size. I'm not a graphic artist, but what I think one of the very largest bricks should be the fact that his fellow officers were listening to his patterns and listening to what he was doing, and they had a problem with it. You heard from Corporal Wilson. She said, I've never taken the time or felt the need to run numbers or to track what a fellow officer is doing, but something was not right with Officer Williams, and we did it in that case. She and another officer, Officer Dunn. I think that is very compelling that you have two coworkers that have concerns about what he's doing. And again, it all goes back to females. It goes back to college age females. And this is the first time we're starting to kind of say, well, it's the alcohol related stuff. So if you just run all his numbers, that includes everything that he's dispatched to and everything he ever does, you know, we have higher females, but nothing crazy. Doesn't match up with the statistics for the rest of the agency should be, but if it's 55% or so, that, you know, we're not sure what to do with that. So this is the first time we're starting to hone in on what exactly it is that he's doing and how he's doing it. Corporal Wiltz also testified that she was not comfortable backing Officer Williams because of concern about the lawfulness of his arrest, and that goes to good moral character. I mean, again, that's that pattern of what's he doing? Is he over-policing? Is he doing what gives officers throughout the country a bad name? When he has officers that will not back him, and she testified that it was both herself and other officers that felt that way. I think that her testimony was very compelling, and she also had a specific reference to a stop where she felt Officer Williams was very, rude or disrespectful. That she made a complaint about how he treated a female in that situation. I think, I did ask her, well, how did he treat the males? She doesn't know because all he was stopping was females. Then we move on to the traffic stops of Dunn and Kennedy. This is a really little brick. This isn't, it seems kind of coincidental that he would stop a fellow officer 4 times in as many years, but she was speeding, so it happened. I think that that's unusual, but that's a smaller brick. Again, though, on one of the Officer Kennedy stops, 32 and a 30, I mean, you're starting to get to the range of accuracy on the instrument, but it again kind of leans towards that over-policing there. It's not the fact that he stopped them, but it's just kind of another little piece in the puzzle that all adds up to the pattern of bias-based policing. We've got the language here of males are calm, they say hello, they high-five the officer. We have females attempt flight from the bar, and they're fearful. It is fine for Mr. Williams to say, hey, in my experience, these individuals did this. What's not okay is to say, males do this and females do this. If we changed this to Muslims act a certain way when they're stopped, or a person of color acts a certain way, but a white person does not. I don't think we have any disagreement about whether that's okay to use the stereotypical language about males do this and females do that. It's not the fact that he's looking for evasiveness and trying to leave the bar or setting down your drink. It's the fact that he's saying, well, basically, generally, typically, that's what girls do. And guys just high-five you. Guys are cool, girls are afraid. It's problematic language, and I think that it's highlighted more if you were to substitute out a different protected class for females. And then finally, you know, everybody knows stats are kind of what you want to make them, but in this case, the stats are undeniable. We've got the Douglas County Sheriff's Office disproportionate stats, and those, they did have concerns, they ran the stats, and again, it was 55% female, 45% male, but what you have to do is look at that in the bigger context of Douglas County Sheriff's Office. 29% female, 71% male. That's a big difference, and we don't have an explanation for that. And then finally, you have the Lawrence Police Department disproportionate stats. And again, if you look at, and this is all in Exhibit 7, the stat breaks down, and the panel's aware of those. But even just from the outset, when you look at his stops, those are higher, much higher than for females, and they're much higher than what the FBI rates are. And, you know, sure, it's a college town, but the FBI stats are nationwide, so they take in both college towns and I think Goodland, Kansas was the example. So they've got that all in there. And yes, you have to compare, you have to be careful with stats, you have to compare, but once you start looking at the OUI arrest, it is disproportionate. And then once you look at the MIP arrest, one female, 84 males. I'm sorry, one male, 84 females. I don't care what kind of stats you want to give me. I don't know how you get around that for as active as he was as an officer. And again, compared to the other officers and the other stats for the agency, it's not even flipped. It's just, I mean, it is a very important stat that in looking at this case, I don't think that you can get away from. Basically, this case, if you go up to Kellogg in Wichita and you want to run LIDAR, you can stop cars all day long. You're going to get speeders all day long. As quick as you can write tickets, you're going to write tickets. So the fact that Mr. Williams is saying, well, I was able to articulate, you know, reasonable suspicion.
I'm going to object. She's over time.
Yes, you are.
Okay.
Please, the panel, thank you for your time and attention. Officer Williams doesn't have to be here. He has no plans to return to law enforcement. He's happy where he's at. He's here to defend his honor. And it is a terrible, terrible thing to be accused of something that he did not do. We do not have a pattern. What we have is the state has created Frankenstein. They've taken body parts from a bunch of different situations and they put them together and they go, look, this is a real human being. They want you to believe that this is Frankenstein. It is not. And I'm going to highlight some of the evidence. I'm not going to go into great detail because I know the panel's been listening. I know the panel's been taking notes. One of the first questions the panel should ask itself is, why does Armbruster, Sheriff Armbruster, make this complaint? Years after Williams leaves, why does Armbruster make the complaint? Read Officer Williams' statement in Exhibit number 9. And he says, Armbruster makes a complaint because Williams was instructed by the chief to start recruiting people from the SO. We all know how hard it is to get police officers nowadays. And he's upset about it. So 2 years ex post facto, he makes these vague complaints because he wants to shut Williams down. He has a motive for shutting Williams down, and it is a bad motive. Let's bounce back to the Sheriff's Department. What do we know about Watts' 3 complaints? Not one of them was substantiated. Not one. In fact, the first one, she doesn't even say she was stopped for bias-based reasons. But they keep harping on the first stop. So, what do we look at next? Let's look at the Volker stop. Williams is exonerated by the Sheriff's Office. Do they look at the numbers? Yes. Was it appropriate to look at the numbers? Yes. 3 command officers, not 1, not 2, 3 command officers look at those numbers and they decide this is not out of the ordinary. So then we fast forward again to Lieutenant Hummer. He admits he has no experience in this area. And it's evident when you look at his statistical analysis that he has no experience in the area. He admits he doesn't even compare like officers and areas to like officers. He, when he looks at the numbers, and you can go through them, they're not 10 to 1 as the officer, the female LPD officer said. They're not 10 to 1. They're not close to 10 to 1. Inappropriate. The state said at the beginning of this case that they would present overwhelming evidence. We're still waiting to hear the overwhelming evidence. Because in the statute that I read in my opening statement, I'm not going to repeat it, it talks about you're not allowed to use bias-based beliefs as a reason for your enforcement action. And I believe it has been established that the overwhelming majority of stops, Officer Williams did not know what the race, the gender, any other descriptor of the driver was prior, that's the key word, prior to him making the decision to stop. Now, in a couple, was he aware? Of course he was. He doesn't deny that. But it has to be prior, and they haven't shown it. In fact, shockingly, we asked Lieutenant Unruh if he went back and tried to look at the reasons for the stops. And out of, I can't remember the number, 230 stops or so, he looks at 3 of them, and he disagrees with the reason. 3 out of 230. Members of the commission, is that overwhelming evidence? I would suggest to you that it is not. Now, if you just look at the numbers, do the MIP numbers look bad? Yeah, they do look bad. If you look at those numbers look bad. But I'm going to quote CPOST's own investigator. You have to look beyond the numbers. That's what really matters. And Ms. Meyer, when she was saying what Officer Williams talked about, I'm sure she didn't do it intentionally, but she didn't quote it correctly. She said he wasn't talking about his experience, he was talking about how he was predisposed. Look at exhibit number 9, paragraph number 6. I have observed. That's how that paragraph starts. He is talking about his experience. Is it valid to rely upon your experience? Of course it is. That's actually called good police work. Has the state come forward and presented there was any male MIP in the bar at the time when Officer Williams made a stop of the female where the male should have been stopped instead? No, they haven't. You heard Officer Williams testify. I asked him, I said, well, did any of the people you did bar checks with who would see who we were stopping ever say to you, hey, what's the deal with you stopping all these women? No. And you know why they didn't say anything? They didn't say anything because the stops were valid. On the Shy Jackson matter, well, do criminal defense attorneys in an effort to try to get their client off some charges ever exaggerate or misrepresent things? Yes, they did. Did the state come in with any videotape, which they have, and they could have shown, to prove what this criminal defense lawyer said he saw? No. Why don't we see any video of these stops? The reason we don't see any video of these stops is they are all appropriate. So what about the female LPD officer? Tellingly, Unruh asks her if she knows why Williams would engage in bias-based policing. She goes, no, I don't know why. Does she come forward and say, he hates women? No, she doesn't say that. Then he goes, well, can you give me a reason? And she goes, no, but the evidence shows otherwise. Well, she doesn't even know the evidence. She doesn't even know the numbers. Because the one day she looked at the numbers, they're wrong. They're not the numbers that LPD based it upon. And I would suggest to you that one of the more stunning admissions that the commission heard testimony on today came from Lieutenant Unruh. Let me see if I can find it. It was on cross-examination. This is in the last page of his report. Quote, this investigation does not determine a specific reason as to why there's such a remarkable difference between Officer Williams' OUI arrests and the issued NTAs for MIP compared to other officers. That's why we're here. Members of the commission, we are here because they are saying the why is because of gender. And the chief investigator for LPD says he can't answer that question. I would encourage the commission to rely upon the language of the statute, 22-4606, subpart D as in David, and the emphasized language was by a law enforcement officer in deciding to initiate. The initiation is the deciding to make the traffic stop. The initiation is observing conduct that would warrant stopping someone for MIP. We're trained in law school to address both sides of the case. I've addressed whether or not I think that there is a basis for the allegations. I would say no, but the other half lawyers are trained to address is punishment basis, because the commission can obviously find whatever it wants to find. So is the punishment of revocation of the certificate appropriate? No. Based upon what I would suggest is meager evidence, if at all, a censure would be appropriate. That's all I have. I thank the commission for its time and attention.
We are over a little bit, but if you want to proceed, there's a couple other things right after you conclude that I would like to tie up before we end them.
Thank you. I just want to point out quickly, as far as a motive by Sheriff Armbruster, there's nothing other than Mr. Williams stating that. And it's not just Sheriff Armbruster that expressed concerns. Again, there was a pattern several years. The numbers were run on him multiple years in a row. The 10-1, Mr. Darrow just stated that that was incorrect. What Corporal Wiltz testified to is that it was 10-1 for one night, and they didn't factor out the self-initiated. So again, if we're comparing apples to oranges, there's nothing to suggest that what she saw that night wasn't correct. And finally, I would just state that we don't have to prove a reason for bias-based policing. No one can get into Mr. Williams' head. Corporal Wiltz can't do it. Lieutenant Under can't do it. I can't do it. I can't tell you why he was doing it. What I can tell you is he did it. Now, you've all had countless hours of bias-based policing. Was it conscious, subconscious? I don't know, but it was pointed out to him, and at that point, that's your opportunity to change your behavior, and he didn't. It just continued to get worse. And the issue here is, he says he has reasonable articulable suspicion for all his stops. He's hiding behind that. Again, if you have speeders just all day long, and you can stop all of them, but you're only stopping the people of color, or you're only stopping the Muslims, or you're only stopping the women, that is what you cannot do. And that, I believe, is what the evidence has overwhelmingly shown that he did. Thank you.
Okay, thank you both. My notes are slightly lacking. We had a significant discussion on your exhibits number 4 through 17, and I don't recall a motion.
I believe that they were stipulated to, at the beginning of the hearing, as my notes reflect, the only thing on the side of Mr. Williams that was not admitted was 18, 19, 20, and 22.
Okay. That clarifies for me. I think those were the individual photographs. Okay. All right. And I think we, at least according to my notes, those were kind of held on reserve. I'm just going to go ahead and admit them if that's possible at this stage in the proceeding. I think we can use our own experience to determine credibility there.
Sorry, is that for which one? Which ones are these?
That's going to be 18, 19, and 20.
I mean, I would object just because there was no foundation laid and they weren't even moved to be admitted, but I mean, certainly if the panel wants to consider them. It's not a strenuous suggestion.
Yeah, we saw them, so we'll have them in the record. With that, it's time for us to conclude the hearing. I want to thank everyone for their participation and their attendance here. It has been a long day, but the hearing's now concluded, and the hearing panel will deliberate the matter once the hearing room's cleared, and a written final order will be issued, and copies of the decision will be mailed to all parties when that occurs. Anything further?
A clarifying question. I know it depends on what comes off the schedules, but what's the standard turnaround time for order after hearing?
It's going to take a while.
60 days?
Yes, yeah. I think that's reasonable. Don't check your mailbox next week.
All right, I think we're done here. We can close the recorder.